Pepsi Prebiotic Cola in original and cherry vanilla. That Pepsi taste you love with no artificial sweeteners and 3 grams of prebiotic fiber. Pepsi Prebiotic Cola. Unbelievably Pepsi.
Listen, all you New Yorkers. Excuse me, taxi.
Okay, we're looking around.
This is the 77 WABC minicast.
Welcome back to Let the Record Show with Chairman Jesse Garcia of the Republican Party. Jesse is the Vice Chair of the New York State Republican Party, as well as being the County Chair of the Suffolk County Republican Party. With us is our co-host, noted attorney, commentator, and essayist, Eric Levine, and I'm Judge Weinberg. And I'm delighted and pleased to have a good friend, a great lawyer, a great counselor, one of the best trial lawyers in New York and probably the country, my friend Mark Zauderer. Mark, welcome to the show.
Thank you. Good to be with you. And Eric, do I remember you or your namesake 40 years ago?
I think you do, actually. I think you do.
Okay. It's a long time.
I'm glad I could reconnect you, gentlemen. So
okay.
let me say this about Mark Zauderer. Not only is he a noted attorney and one of the great trial lawyers, but he is a go-to person as an advisor to many distinguished senior judges and great judges in the history of the state of New York. He's been a member of or helped run many study groups, commissions with the New York judiciary. Additionally, he's a leader of bar associations, including the Federal Bar Association. And I know him because when I was sitting on the bench and he was doing a very famous case involving the Astor situation, I used to see him in front of 100 Center Street all the time, and we always had the opportunity to chat. But Mark decided that he was going to write a book, and the name of the book is called Counsel, The Courtroom is Open, and it's described as lessons from more than a half a century in law and life. So there are 3 questions I'd like you to focus on Mark. First question is, why did you write the book? 2, what are the lessons you have for law and life? And what concerns you most about the future of the legal profession and, in fact, of a lawful society here in the United States? So I turn it over to you. Why did you write the book, Mark?
Well, thanks for asking. It's kind of interesting, I think. The idea first came up 25 years ago. I was speaking with the former governor, Mario Cuomo, who at the time I was president of the Federal Bar Council, and he was a speaker in the grand ballroom, the Thanksgiving lunch of the Federal Bar Council, and he really hadn't spoken with lawyers in many years, and he put his mind to it. He began to draft a speech, and he went back and forth with me. How is this? Is it too serious, too political, too long? And we spent some time on it. I gave him some suggestions, and then he turned to me, and he spent about an hour asking me about my own life. And at the end of that, he said, Mark, why don't you write your autobiography? And I was flattered, but didn't think twice about it till about 2 years ago when my grown son, Daniel, said, Dad, why don't you write your autobiography? Somehow the idea resonated, and I said I would do it. And it started there, and it was really a very enjoyable experience doing it. And I was happy to share my thoughts in this book, which is published just the other day, and it's being widely distributed by Simon & Schuster, and I hope people have the opportunity to hear some of my thoughts. I think your second question was, remind me.
Second question is, what are the great lessons you've had in life? You're a very young guy, even though you've had 50 years at the bar, and I think there are lessons we all get as lawyers or political leaders or governmental leaders about not only the profession that we're in, but also about life itself and what this all means. So what great lessons did, as you sat down and wrote the book, you were thinking about this in terms of lessons? This isn't just anecdotal. This is about real life experience that led you to certain values and certain lessons. What were they?
Yes, that's very well put. What occurred to me, and this is a theme throughout the book, let's start with law. We always thought of law as the profession of law, not the business of law. And over the last I would say 30 or 40 years, there's been this migration from what we thought of as a learned profession, just like accountancy or medicine, into what's called typically the business of law. At the time when I started practice, we were the profession of law, often serving the businesses. We were not the business of law. And that really occurred to me some years ago. I was watching the Super Bowl, and there was a minute-long ad, and we know that those ads are very expensive, and a lot of thought goes into them. And it was an ad by one of the major accounting firms and said, "We are in the business of accounting." And at that point, I thought, why did he not say, "We're in the profession of accountancy"? And the book talks about some of the factors in society that have detracted, I think, from the legitimate image of the learned professions. We are the inheritors of what was once a guild system, where professionals were called the learned professions. I mean, the word was right in there. And in law in particular, I have a chapter on that in the book, which is, what has happened to law firms. A number of things have come into confluence that have produced that change, and it's not been all for the better in society, in my opinion. I'm wondering if someday we're going to be the business of medicine. Every profession will no longer have that appellation. So, a couple of things have happened in New York and major cities since I began practicing law. Law firms were once homegrown institutions. The major firms that we know today were typically in one city. In New York City, for example, which had major law firms serving particularly the financial community. And over time, several things happened. One, I think, the rise of the focus on what we call the profession still, I think, in investment banking firms. The income that was really quite high was beginning to be observed by lawyers, and they felt competitive. Also, we had the American Lawyer, which was an industry publication, which began to emerge in the late 1970s, was reporting the income of what some lawyers were earning in major law firms. And that became much more the focus. One time, I think for lawyers in society, the coin of the realm was not money. It was respect in the community, dignity, which was well earned through the very moral practice of law. And at times we've seen some of those morals challenged. Lawyers were not supposed to subscribe to the morals of the marketplace. They were assumed to practice with a certain credibility and integrity that was far above that. And I think the final influence, I think, that's caused this is as clients grew to have international needs. They had cross-border transactions. They operated in different countries, and they wanted law firms to be one-stop shopping. And so for law firms to meet that need, they had to expand. And whereas at one time, lawyers who came out of school joined these firms and rarely moved beyond those firms if they became partners, were inculcated with the firm culture. By the time they became partners, they had been there 8 or 9 years, and they knew the firm values. But to meet the expectations of these international clients, they had to grow by aggregation, acquiring firms by a very narrow set of criteria. How much business do you have? How many hours are your lawyers billing? And so those that came to the law firm came from another firm from which they had no loyalty, and were often, if they were dissatisfied with the new positions, would move on to the next firm. So there was no coherent culture, and that began to dissolve. And that's affected the profession in another way, which is look at how young lawyers are compensated. They're compensated often by according to a minimum hour requirement. They don't get bonuses unless they bill, let's say, 2,000 hours. And I remember when I was an associate, I guess Eric would probably, who's on this broadcast, would remember it. We would get annual reviews as young lawyers. We wouldn't even know exactly how many hours we billed unless we kept our daily time logs and added them up over the course of a year. It wasn't emphasized. But today, it's a mandatory requirement in many firms that lawyers have certain minimum hours. So all of those factors have come into confluence to create what I think is a shift from what we once knew as the profession of law to the business of law.
And
I'll pause there.
And what's the impact to the larger society of that?
Well, because this has occurred not only in law but other professions, I think that this has contributed to cynicism in society. Clients, and I know in the law profession, tend to have much less friendly relations with the law firms. They scrutinize the work, they scrutinize the billing, and I think the same is true in other professions. Accounting is one. I think, again, medicine is another. Doctors are often trained now to prescribe, in my experience, and maybe all of us as consumers, they order tests or prescribe medicines according to what they can be compensated, by insurance companies. So,
or to avoid malpractice claims.
Or to avoid malpractice claims. That's right. And that's been, I think, a very unhealthy factor that's intruded in the doctor-patient relationship.
I'll just tell you one anecdote, and I'll turn it over to Eric. One anecdote that I still remember the day it happened. Like you, I was a law clerk to a federal judge, and I was in the U.S. District Court for the Eastern District of New York, and my judge was Judge Henry Bramwell, who had been both a state Supreme Court justice and later a U.S. District Court judge. And we had a case one day that came across and had to do with a challenge to lawyer advertising, that the ban on lawyer advertising by the Bar Association ethics groups was being challenged both on First Amendment grounds and on antitrust grounds. And I did the research with the judge, and he asked me what I think. I said, I think this is going to be a winning challenge to the ability of the bar associations to ban lawyer advertising. And the judge looked at me and he said, Richard, he said, that will be absolutely awful. Lawyer advertising will be the death of this profession. Your thoughts on that, Mark, and I'll turn it over to Eric.
Yeah, I would punctuate that point. I think it's excellent. All we have to do is think about the last time you were on a bus or a subway train, and you looked up and you see the advertising in many different languages. Now, the idea originally was I think a healthy one, that bar associations were accused of price fixing in many situations. Lawyers would charge a fixed fee, as recommended by the Bar Association, so nobody could compete for a client at a lower cost, so to speak. But the side effects of that, as I think you're suggesting, have been reprehensible in many cases. You see lawyers advertising on television, chasing clients. They try to be careful not to make what we call actionable misrepresentations about their skills, but they say, well, we have billions of dollars of verdicts, and they have in fine print on the bottom of the ad, past results are no guarantee of future results. But it's pretty obvious to anybody who has surveyed the situation and has been around for decades that the trust that was once there has really been eliminated, and this is a competitive business for lawyers, and I don't think it's healthy for the consumer.
Eric.
Yeah, so, Mark, I agree with everything you were saying in terms of going from a profession to a business. I think it's important for listeners to understand the evolution of this. If you go back, I guess up until maybe the 1980s, before then, really many of the large firms were Catholic firms, Jewish firms, WASPy firms, Irish firms, and the Irish firms didn't hire the Jews, and the Jews didn't hire the Catholics, and the Catholics didn't hire the WASPs. So everybody was kind of in their own lanes. And then eventually, people started looking at it and say, maybe we really shouldn't be segregated in this way. And we have to start cross-fertilizing. We want the best talent. And it became much more of a meritocracy. So many of these firms, once you were in a firm, assuming you hit some certain minimum requirements, eventually you became, it was like a fraternity. I mean, they're just primarily male. They're fraternities, and you eventually became a partner. And then your kind of life was set. But as these barriers came down and people were hiring, and these firms were hiring, hiring women, hiring blacks, hiring Catholics, hiring Jews, and those barriers came down, it went from a fraternity to a business. became strictly a meritocracy. And that's good and it's bad. We all support meritocracy. People should be rewarded for their contributions and their successes and their achievements, not the color of their skins, not their races, not their religions. But there's a consequence of that. And so these things turned from fraternities into businesses, into bottom lines. And now you have this 2,000 hours. I remember that very well. In my first job at a law school, I was working in one of the large firms. You had to have certain minimum requirement if you wanted to get a bonus. But now it's gone too far, and this is what I really would like you to comment on. It's gone from a meritocracy. It's gone from the fraternity to the meritocracy, but now it's going back to we look for Catholics, we look for blacks, we look for women, we look for trans. The ABA has played a large part of this. It's a very left-wing organization, and it fosters and encourages law firms to adopt diversity, equity, and inclusion agenda, which in my opinion are unconstitutional, racist, and anti-Semitic. But they encourage law firms to have a certain number of blacks, a certain number of women, a certain number of trans, and to have DEI. And I think that's the next evolution, or we're in the middle of that evolution, which is clearly for the worse. I was just wondering if you'd comment on that.
Sure. Well, there's a lot to unpack there. And like I think in many things in life, several things could be true at once. I think on the positive side, what you've just very, very well described in the evolution of democracy in law firms has had a healthy aspect. At least it did some years ago. I remember, coming out of law school and hearing the names of some of these firms, white shoe firms, that I said I could probably never get a job there. Many people assumed that, and many people either had difficulty getting jobs there, or if they were associates, certainly had a difficult time becoming a partner there. Some years ago, I represented a major law firm, whose name you would know, I prefer not to say it, in a $500 million malpractice suit. And I had known the name of that firm coming out of law school. This is decades later. And I met with the management committee of 5 people, and 3 of the 5 were Jewish. Now, that never would have happened before. I never would have thought that was the case, but it was. On the other hand, I think we've seen the difficulty of melting or merging what you're referring to as really a more democratic meritocracy with what have been challenged as preferences. And many have suggested that in the effort to achieve democracy, standards have been compromised. I mean, that's a major issue in society, not only in law firms, but in universities, in public corporations. So, this is the complication that I think we're facing in society, and some argue the balance is not being struck the right way.
Well, Mark, I think people should read this book because it's a great book. I started reading it the other night. There's some interesting chapters in there that I knew a little bit about. I was paying attention to it. The name of the book is called Counsel. The Courtroom is Open. It's lessons from more than a half a century in law and life. It's written by my friend, one of the great trial lawyers of our country, Mark Zauderer. It's being published by Simon Schuster. Mark, if people want to get this book, how do they get it?
Yes, thank you. It's being very widely distributed. You can go on Amazon, Counsel, The Courtroom is Open, or Mark Zauderer, Target, and all the major retailers. I'll be doing some book signings, including on Barnes & Noble on Fifth Avenue in New York in May. And I would just like to say, this was one of the inspirations, the author's profits from this book are being donated to Grassroots Grocery. It's a not-for-profit founded by my son that distributes food to those in need in the Bronx in New York City. And so I was very proud and privileged to do that. And I thank you for bringing attention to this book. I think you'll enjoy it. It's not just a story of cases, but it has my thoughts and questions about many of the issues that you've just asked me about on this program. I thank you for doing that.
Well, once again, on behalf of Chairman Garcia, Eric Levine, and myself, we want to thank you, Mark, for joining us. The name of the book, again, is Counsel. The Courtroom is Open. It's written by a distinguished attorney and leader of the bar, Mark Zauderer. Zauderer is spelled Zauderer. It's available at Amazon. There'll be book signings at Barnes & Noble. Mark, thank you for joining us today on Let the Record Show. And to our audience, Jesse Garcia, our distinguished chairman of the Republican Party, noted attorney, commentator and essayist Eric Levine, and myself, Judge Richard Weinberg, want to thank you for listening. We look forward to being with you next week. And once again, God bless you, God bless your families, and of course, God bless America. Thank you for listening.
Ryan Reynolds here from Mint Mobile. I don't know if you knew this, but anyone can get the same premium wireless for $15 a month plan that I've been enjoying. It's not just for celebrities. So do like I did and have one of your assistants switch you to Mint Mobile today. I'm told it's super easy to do at mintmobile.com/switch.
Upfront payment of $45 for 3-month plan, equivalent to $15 per month required. Intro rate first 3 months only, then full price plan options available. Taxes and fees extra. See full terms at mintmobile.com.